Hello. No. Ladies and gentlemen, thank you for being here in this marvelous Hall of Justice. I am Jean-Marc Touvenin. I am the Secretary General of the Hague Academy of International Law. I'm very, very honored to have been invited by the Carnegie Foundation to moderate and say some words during this panel. I will present to you our guest in a minute. But perhaps, first of all, I would like to say that the Carnegie Foundation had a very good idea, in my view, to devote one panel to the question of the role international plays with respect to peace. And indeed, the question we will address during this panel is what international law and the institutions dealing with international law can bring in terms of international peace. Now, discussing this topic could of course look quite normal, since three of the main institutions aiming at promoting, interpreting and implementing international law, including in situations of conflict sometimes, are located in the Peace Palace premises, namely the International Court of Justice, and we are in the place where the International Court of Justice sits normally, the Permanent Court of Arbitration, and the Hague Academy of International Law. These three institutions are important. The ICJ and the PCA settle disputes between states legally, not with arms and ammunition, with words, legal arguments. They say what is right, what is wrong, what is true, what is not convincing, according to a common language, which is international law. The ICJ can also, if it is correctly asked a question by the right organ, can also clarify what international law means, what it says, in the context of its advisory opinion jurisdiction. That is a huge contribution to calm down international relations in a peaceful way through law. And this panel is very honored to have the presence of the Vice President of the ICJ, Ms. Xue Hanqin. Mrs. Xue Hanqin is a distinguished professor of international law. She has served for the Ministry of Foreign Affairs of China in different positions, high-level positions. She has served as ambassador of China to the Netherlands and to the ASEAN. She has been elected by the UN General Assembly as a member of the International Law Commission for 2 terms, and she has chaired this high-level UN body. She is a member of the Institut de Droit International, and she has served as a member of the Curatorium of the Hague Academy of International Law for 6 years. Unfortunately, before I was elected Secretary General. She has published extensively on international law, including a very interesting course in the Recueil des cours de l'Académie de droit international de la Haye. And I perhaps should underline that even the Americans, they call it the Recueil des cours, which is the right way of saying, but the English, they say the collected courses. Thank you very much, Mrs. Vice President, to be here with us. As you all know, the ICJ is a body of the United Nations. The United Nations is in New York, and the head of states and governments are meeting today in New York. The United Nations is also in Geneva, but it's also here in The Hague through the presence of the ICJ, which is a UN body. But of course, the United Nations is also rich of other bodies, including the Committee of Human Rights. And we are lucky to have in this panel Professor Hélène Tigroja, who is a member of this committee. She has been elected recently. She has a fresh approach of what has to be done and what has been done in the context of the work of this Committee of Human Rights of the UN. And her experience will be very, very useful, I think, for our conversations. Thank you, Hélène Tigroja, for being here as well. The Hague Academy of International Law, for its part, promotes a better understanding of international law, explains its mechanisms, its substance, its limits, and also the challenges it has to face. It has done so for the benefit of thousands of attendees to its courses, and will go on doing so for the benefit of further thousands of attendees. I am representing the Hague Academy today here, but also I am very glad to have in this panel Dr. Bott, who is the president of the Administrative Council of the Carnegie Foundation, but also he is presiding the Administrative Council of the Hague Academy of International Law. So needless to say how honored I am to have him with us to discuss perhaps his experience as overviewing everything which happens in the Peace Palace, which is the center of international peace and justice, and so its experience will be very useful also to our conversations. Now, let me broadly introduce the purpose, if I may, by saying that the institutions I've just mentioned are important and are more than that, they are the proofs that our history can move sometimes, and indeed not many times, for the better and not for the worst. The proofs that we are making progress in the direction of the establishment of a more peaceful world. Now, what is peace? Today, the definition of peace is really broad. And to tell the truth, quite complex. And I think that the 3 days that you are following here in the Peace Palace during this Carnegie peace-building conversation show the complexity of how to address peace. It has many, many questions to be answered. But when the Peace Palace was built, the notion of peace was more basic, more simple to understand. It meant absence of war between states. In other words, peace was the situation characterized after a war and before another war. Now, international law discusses peace for a long time. Peace treaties exist since a very long time, and indeed the very first treaties we know were peace treaties. They were dealing with peace and commerce. And all along our history, a lot of treaties of friendship and commerce have been signed. They exist since the ancient Greece, but also we found some traces dating back to the early ages of the pharaonic Egypt. But these treaties certainly were not discussing about war. They were not discussing about establishing peace. They were just taking into account a situation of peace that was established and trying to build over this period of peace to develop commerce and other kind of relations. They were not guaranteeing, not even aiming at guaranteeing a long-lasting peace. War was always possible and contemplated as a sort of normal way of conducting international politics. Sometimes war was limited to a certain limited purpose, and sometimes wars were total. Now, despite peace treaties, obviously, total wars, the most bloody ones, have indeed also a long history. The first documented one was the Peloponnesian War between Athens and Sparta between 431 and 404 before Christ. The 30 Years' War between 1618 and 1648 in what is now Germany is another example. And the French Revolution, I am French, but I must say that the French Revolution led France to devote the nation's entire resources into an unprecedented effort of war with the so-called levée en masse. You know that the European leaders tried in 1815, after the defeat of Napoleon, to achieve stability in their relations through a policy of balance of powers, aiming at preventing the hegemony of one nation over the others. So it was the epoch of the Concert of Nations, of the European Concert, and they tried to establish peace through rapport de force, to tell it in French. And we can speak French in this place sometimes. But the Europeans at this time did not hesitate, nevertheless, to use military violence to promote their economic interests, purely economic interests. The two opium wars around 1840 and around 1860 between the British Empire and China is a good example. China had also at the time to face a sort of total civil war during the Taiping Rebellion, which lasted from 1860 to 1864, and it is reported to have been bloodier than the First World War. In Europe, in the continent, here, the Europeans used to continue their wars between themselves, as exemplified by the Crimean War and the Italian War around the middle of the century. But during the Italian War, one of the battles, the Battle of Solferino, had been witnessed by a Swiss businessman, Henri Dunant. Horrified by what he had seen, he wrote a book and made proposals, which eventually led to the creation of the Red Cross Committee and to the adoption of the first Geneva Convention in 1868, which marks the birth of the international humanitarian law. Something was moving. Treaty law was recognized as capable of limiting the use of violence during wars. Who could think of that? During the American Civil War, another progress was made with the enforcement of the so-called Lieber Code, named after the name of its author, a German lawyer, who meditated at the time for the adoption of laws to be respected during wars. This was a decisive inspiration that led to the organization here in The Hague of the peace conferences of 1899 and 1907, and to the adoption of a series of conventions on the law of war. Now, the Hague peace conferences are obviously a very important moment in our contemporary history. But funnily, these conferences did not really talk about peace. They were talking about war and how to make some rules respected during the time of war, during the battles. Nevertheless, during these conferences, the parties tried also to put in place alternatives to war, namely mechanism and judicial mechanism to settle international disputes peacefully. Here was born the Permanent Court of Arbitration in 1899. It is still going on, and it is working more than ever nowadays. The other conventions signed during the peace conferences addressed different questions to be answered during wars. To be noticed that the second peace conference of The Hague discussed also of the creation of the Hague Academy of International Law. In 1907, the delegates had the idea of launching this academy to educate the world to think legally and not only in terms of rapport de force. Now, of course, as you may know, a third Hague conference was supposed to be convened in 1914, a third one. But, and at the same time, the Hague Academy of International was supposed to be launched. But, of course, the First World War rendered that impossible. Now, after the First World War, the movement claiming, it was a philosophical movement until then, but the movement claiming, it became political, that war should be outlawed, amplified. Of course, the League of Nations, the pact, the League of Nations covenant does not do that. It does not outlaw war. But some years after that, in 1929, the Briand-Kellogg Pact went as far as to prohibit war as a means to settle international disputes. 1929 is the very first real convention where international law says no to war and says that war is unlawful. It did not work. Obviously, it did not work. Second World War is a sufficient proof of that. But after the Second World War, the idea stayed alive and took place in Article 2, Paragraph 4 of the UN Charter. Article 2, Paragraph 4, by which all the members accept to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purpose of the UN. The whole project of the UN is to outlaw war and to establish a system of collective security in case of some state would not respect the prohibition of war. Since then, since 1945, we know what happened. But it is a long story. I cannot trace it back now. I just make some points. On the dark side, let us remind the Cold War, but also all the hot wars, including some of the worst, in Asia, in Vietnam, but also in the east of Europe, and in Africa very recently, wars during which we learned that what we thought impossible, genocide and ethnic cleansing, was in fact possible to see on the ground. And it was not long ago. On the dark side, there is also this incredible new form of insidious total war using terrorism as its main weapon. On the bright side, the main heritage of our ancestors of the late 19th century and in the middle of the 20th century survived, until now at least. Multilateral institutions are still standing. The UN has survived and works more than ever to improve long-lasting peace by conducting many actions of prevention, education, reconstruction, building, etc. The ICJ is there, more active than ever, and the same goes with the PCA. And many other international courts or tribunals have saw the light, including courts of human rights. The Hague Academy of International Law has never been so attractive. Human rights are now a world standard. Yet, international law is facing today a real crisis, since we do witness a sort of systematic enterprise of destruction of the international legal order that we have inherited from the past experiences, and more generally, a destruction of the multilateral governing system progressively and passionately elaborated through the years. Now, the Secretary General of the UN said, I think today, as follows, which is, I think, the view of an expert. I quote, "Multilateralism is under attack from many different directions, precisely when we need it most." I agree with this statement. International law is facing, and the international legal orders are facing a crisis, and the rule of law in the international sphere seems to fade away. And the problem is that the civil society is not reacting that much. It is not arguing for protecting multilateralism. In general, civil society stays silent, or even worse, applaud, or claims for the abandonment of multilateral institutions. Even in the academic sphere, a number of my colleagues devote their time and energy to demonstrate how bad is international law. It is oppressive, it is non-democratic, it is colonial, inexistent, it is not law. And even if it is law, it's not international. People who read the law reviews can read that page after pages. Now, neither international law nor the international legal order are perfect. No one never said that. But we try hard to improve them. And I personally think that those who only want to destroy should like to construct. Now, as I said, the world faces challenges, but it stays that the international institutions, the Peace Palace, the ICJ, the Human Rights Committee are still standing. I'm very proud to have such high-level panel to discuss of what international can bring to peace. I finished my introductory purpose, and now I will leave the floor to Vice President Xue. Thank you, Vice President.
Thank you, Professor Tunneman. I will continue along the theme of his speech. First of all, I'd like to express my sincere appreciation for being invited to join this panel. And I will use the time to talk mainly about the court. As you know, the International Court of Justice, we call it the World Court, or the court, is the principal judicial organ of the United States.
United Nations.
Of the United Nations, I'm so sorry. United Nations. And one of the 6 major organs of the United Nations, alongside the General Assembly, the Security Council, the Economic Social Council, the Trusteeship Council, and the Secretariat. And this is the only organ of the UN that is located outside of New York, the headquarters of the United Nations. So people often ask why the court is located in The Hague. Why is it sitting in the Peace Palace? And then the question, what's the relationship between peace and justice? We know this building was not particularly built for International Court of Justice. Initially, it was the outcome of the 2 Hague peace conferences. The first one was held in 1899. The conference was called actually by Russian Tsar Nicholas II in face of increasing arms race and maritime rivalry among major powers for spheres of influence and colonies overseas. The outcome of the first peace conference did not produce much on arms race, but at least it has one tangible result. It concluded the Convention for the Pacific Settlement of International Disputes, by which the first World Court of Arbitration was established. And we know during the second half of the 19th century, due to the peace movement in Europe, more and more treaties contain clauses on arbitration to encourage states to settle their dispute through arbitration. So there is very much a call for peace, for pacific settlement of international disputes. As Professor Tunneman just now mentioned, for a long, long time, societies use force to settle their disputes. Ever since we have international law, use of force was legitimate. States could use war to pursue its national policy. So for a long time, international law had a law of a war and a law of a peace. And not until 1928, when the Kellogg-Briand Pact was concluded, for the first time, war was denounced as a means for national policy. But we understand when in 1990, the Permanent Court of Arbitration was founded, it was mainly a permanent bureau, not in the true sense of the term, a court. But because this is the event held by Carnegie Foundation, I'd like to say a word about how this building came into being. It was thanks to Mr. Andrew Carnegie, who donated 1.5 million US dollars, that made it possible to build this building. It was originally designed to host the first permanent court arbitration and to offer the venue for international conferences, because the first Hague conference was held in the royal palace of Queen Wilhelmina. And then they found the need, they felt the need, they need a place for international conferences. And of course, at that time, people were very dubious about means of arbitration to settle international disputes. And indeed, in reality, the establishment of the permanent court arbitration did not prevent war and was not able to prevent the wars. And the First World War broke out in any event. And after First World War, the First World Court was established to encourage states to settle their disputes through judicial means. That's how the First World Court came into being. It was called Permanent Court of International Justice. But that court was not part of the League of Nations, and its statute was not part of the League Covenant. And the court lasted from for a couple of years, for over 20 years, and from 1922 to 1940, when the First World War broke out. And during that period, the First World Court settled 36 contentious cases and provided 27 requests for advisory opinions. And again, the First World Court did not prevent the World War again. Once again, failed mission. After Second World War, when the Allied states designed the post-World War II world order, they decided to establish a general international organization in which they proposed to set up a world court, and with its new mission. So that's why they make this international court as the principal judicial organ of the United Nations and one of the 6 major bodies of the organization. And as the First World Court, they located ICJ in this building, in the Peace Palace. That's how we find ourselves in The Hague rather than in New York. And you can see throughout history, states and peoples try to find way how to find a possible way to settle disputes between states. But more important is the fundamental principles of international law were laid down in the UN Charter. These fundamental principles mainly reflected in Article 2, Article 1 and Article 2 of the UN Charter. For instance, the sovereign equality of states, peaceful settlement of international disputes, and non-use of force, threat of use force in international relations, and non-interference in internal affairs, and the principle of international cooperation. By then, you can say, under international law, use of force was prohibited. And of course, as Professor mentioned, there are two exceptions. Only in case of self-defense, one state still can use force. Secondly, that's in case of collective security system. Only by the decision of the Security Council that force can be used for the world peace and security. And under the principle of a peaceful settlement of international disputes, we know we denounce the war. We have to have a means to settle the disputes between states. And throughout history, states and societies use various kinds of means to settle dispute. Of course, a war was always resorted. But through state practice, they found various means that are peaceful and useful for settling international disputes. Bilaterally, states can settle their disputes, first of all, through negotiations, and then through good offices of third party, fact-finding, and then conciliation, mediation, arbitration, lastly, judicial settlement. Of all the third-party mechanisms, of course, most compulsory is the judicial settlement. So that's the mission for international courts. But for a long time, states were very much dubious about the judicial settlement. In the late 19th century, when the idea just came out, states, particularly big states, doubted whether they ever could elect impartial judges. They questioned how judges of impartial judges can be elected. So the idea was dropped during the peace conferences. But later, the League of Nations managed to resolve the problem. So the Council and Assembly of the League together elect judges. Now today is through the election of the Security Council and the General Assembly simultaneously they elect judges. And these means helped to prevent the war. And this is big development. Through the World Court, you may ask, what kind of contributions World Court has made to the world peace? The court has two jurisdictions. One is called Contentious Jurisdiction. It settles disputes between states. We call it the Contentious Jurisdiction. Secondly, it gave advisory opinions requested by the UN organs, Security Council, General Assembly, and other bodies for any legal question. They can request a court for advisory opinion. The first jurisdiction for disputes, contentious jurisdiction, the court decision is a final, binding, without appeal. And parties to the dispute must comply with the decision, because under Charter, states has accepted the obligation to comply with the court decision once they agree to the jurisdiction of the court. For the advisory opinion, advisory opinions are not binding in the strict sense of the term. But in these opinions, the court will pronounce on the law, clarify the law. That play a very important role for the development of international law. So whether states appear before the court, whether they file a case in the court, any state would attach great importance to the jurisprudence of the court, whether developed in the contentious cases or in advisory opinion cases. And we say the court makes its contributions to world peace through rule of law. And you ask me, how can you explain that? I will say what kind of cases we deal with. First, and very, very common, is the territorial disputes, armed conflicts at border regions. That's very common. States, if you look at our cases, we find, states have armed conflict at the border. One said, this is my territory. The other said, that's not true, it's mine. And then may end up in the court. And then we settle that dispute. And that will prevent armed conflict. That's a straightforward case. Second type is maritime delimitation and maritime disputes. We have quite dozens of cases in this field. And more recently, we have a much larger coverage of subject matters. And we have cases relating to state immunity, state responsibility, human rights, environmental issues, protection, conservation of natural resources, international criminal law, and actually more and more states appear before the court or seek judicial recourse for the settlement of their disputes. So there is a clear link between peace and justice, between peace and the rule of law. And that's the contribution the court is making. So in carrying out its judicial function, the court is playing an increasingly important role in the maintenance of world peace and security. In this regard, the court remains grateful to Mr. Andrew Carnegie and the Carnegie Foundation for the contribution they made for the establishment of the Peace Palace and ultimately for the world peace. I thank you for your attention.
Thank you very much. Thank you very much. Now we see that international law offers a lot of tools for states to settle peacefully the dispute, but the tool can achieve what they are aimed for if states use them. The question is, perhaps to President Bott, do you think that the Peace Palace is a source of inspiration as such for states to go towards justice that is offered in this building?
Well, first of all, ladies and gentlemen, thank you very much for being here and for sharing with us a number of thoughts about peace through law. A very complex subject, I must say, especially after having attended today almost all the dialogues, all the peace dialogues in various institutions and forums. And I was very intrigued by the fact that nobody mentioned the fact, when we were talking about war and prevention, that almost nobody said the Peace Palace is an institute of prevention, of war prevention. Because so many cases have been submitted to this court and are being submitted to this court. And not only to this court, but also the International Court of Justice, but also to the Permanent Court of Arbitration. Many people said, can you imagine, billions are being spent on war and only 500 million on prevention. And I wanted to get up and say, but you forget that prevention is a wider notion. It's not only a question of money, spending in areas of conflict in order to prevent a further, let's say, a further escalation of the situation. What we are doing here is prevention. Well, you have, and I will not reiterate what the court is doing and what the Permanent Court of Arbitration is doing, not to speak of the Hague Academy and the enormous body of law that is being developed there through great legal minds. I will also say a few words as a politician. I've been Minister of Foreign Affairs, and as such I was also involved in the conflicts in Iraq and in Afghanistan. As you know, the Netherlands had troops there for a prolonged period, and as a result I frequented, let's say, those countries, talked about the warring parties. And there were three things that struck me, and I think when we talk about law and about application in order to create peace through law, that there are three challenges. The first one, I think, is peace. A number of years ago, the University of Utrecht organized a seminar about peace treaties. What is the result of peace treaties? If we analyze them, what do they bring? It was a fascinating seminar. I also was able to make a little contribution, but the effect, especially of the Treaty of Versailles, was that if you look at the consequences, at the effects, that we are disappointed, because a peace treaty obviously does not always lead to a period of peace. It can be the foreboding of the next war if you don't, let's say, create a peace treaty that enables the parties to settle not only for an absence of war, but let's say for a period of mutual understanding, rebuilding, re-emerging and bringing countries together. So I think that the word peace, as you said yourself, is a very elusive something. We discussed it this morning, and I think nobody was able to give a proper definition of the word peace. And we had just a few moments ago Rabbi Soetenhorst, who said, for me, peace is a wholeness, which you cannot quite describe, but it is there. Now, that is rather abstract, but I understand more or less what he means. It is a situation in which you not only have an absence of war, it's also a situation in which people can develop themselves, in which we can, let's say, create new elements, new situation for mankind. So that's my first challenge, you know, that we have problems with peace and with the consequences of peace. The second one is that listening to all these stories today, and again here, we of course are talking about conflicts between states. Mm-hmm. The International Court of Justice deals with conflict with states. But we see increasingly that conflicts do no longer take place between states. They take place between warring factions, mostly within one country. If you look today at the world map and you identify the hotspots, so to speak, you see that you are not talking about wars between states, and I think that is also one of the problems for the international courts. We're talking about factions with all kinds of different opinions, allegiances, and more interesting even, allegiances to countries, to states. If you take Syria, you see that Russia is implied, Turkey is implied, Iran is implied, maybe even Israel is implied, Saudi Arabia is implied. They are fighting each other, but if we are negotiating, we try to negotiate not with these warring factions, but we negotiate with states. And that's a very interesting, it's a paradigm. On the one hand, you see that war is taking place increasingly not between states, so courts in effect could not settle those problems, unless, of course, the countries behind the fighting factions would be willing to submit. But that would, of course, more or less admitting that they are wrong. And they do not think that they are wrong. So I think it's a tremendous dilemma. How does international law cope with this entirely new situation? And rather than concentrating all the time on interstate war, and we haven't seen interstate war for a long time, but how do we cope with the increasing intra-state conflicts, which often are more violent, more serious, more victims, more upheaval. If you look at Syria at the moment, or at Iraq, and you see the consequences of war, you're horrified. I remember when I was a young child, I traveled through Germany, and I saw the devastation of the Second World War. If you travel through Syria at the moment, you see the same thing, maybe even worse. And that is not because we have just witnessed a world war. No, we have had a ferocious fight lasting 5 years and more or less going on today. Then the third problem is, of course, we are developing law. But such conflicts, what is the applicable law? What kind of law are you going to apply? Unless you say, I believe that not the Taliban or whatever are responsible, and we think that the law of the nation should apply. But I remember sitting in Afghanistan. I was there quite often because, as I say, for 1.5, 2 years we had troops there. And I had many of those yergas where I sat together with the tribal chieftains talking about peace, because there was a sort of a period of relative quiet, and we discussed ways for rebuilding the country and what to do, etc. And I remember that a number of these chieftains said, you are talking about your law. What you do not understand is our law. And I think, and I've witnessed the same thing in Iraq, if I talk there with, let's say, people from the provinces, etc., they said, you talk with the eyes of Western law, but we have our own laws. And before you judge, you should first, let's say, investigate and examine what kind of laws we have. Perhaps the laws coming from the Quran, or there are local laws. So I think if you want to really create peace through law, we should not only look at the learned volumes of the Recueil de Cour, although I think, of course, they are the most beautiful compilation of international law you can imagine. But I think that if we look into the future, as lawyers, as peacemakers, that we should also reflect in our own hearts and in our own minds and say, yes, it's true, you know, we look at those situations with Western eyes, with Western laws, well, Western laws, international law as it has been developed over the ages, and as we lay it down in all these volumes and books, etc. Whereas the people who are most affected by war or by strife have perhaps a different concept of what the law is and feel therefore justified to continue the fighting. And as I say, these three dilemmas, these three challenges, I think are three topics that also should be, let's say, examined, looked at, and that we together in a different venue and at a different moment should perhaps explore to see how we are going to tackle these problems and how we can find solutions to them. I don't have them right away. I only remember that when I talked to these people, I said, well, then you taught me what is your law, what is your concept, etc. Tell me, write it down, because then we can deal on the basis of what you believe, and we can try to interpret it, perhaps, in the context of our laws and what we have developed. And maybe the twain can meet, East and West, you know, etc. So these are my reflections. This being said, I'm, of course, an optimist. And I believe that the Peace Palace still fulfills an enormously impressive and important function. Also, if you look at, let's say, the number of cases, number of cases also that are solved in the courtroom are increasing steadily. I think that when the palace opened its doors, there were some 5 cases per year, and nowadays we are getting used to facilitating 3 hearings per week. So you see that, and the same is true, of course, for the Permanent Court of Arbitration. So without belittling what is going on in the courts, and I think they're very important, and fortunately we have the Peace Palace where all these things are taking place. I think that as, let's say, lawyers, and although I am not a practicing lawyer at the moment, I am a lawyer by education, I think these are challenges that are interesting and that perhaps should be examined at the next meeting of the peace conversations. Thank you very much.
Thank you. Thank you, Dr. Bott. So I think that it's really fortunate because we have Elenti Gurjan, and I think that she will make the link between 2 of your challenges, conflict between non-states and applicable law. Isn't it the case that the Security Council, which is a body also involved in peace through law because the Council applies the UN Charter, is kind of bringing an answer?
Yeah, thank you. Thank you very much, and I'm very happy and very honored to be here with you and to have this conversation. And indeed, I'm going to try with some illustrations to put some ideas on the table, or at least some reflections. So maybe I can make 2 kind of remarks. The first set of remarks regarding, as Professor Tuvna said, the practice of the UN Security Council and the current practice and the very recent practice of the UN Security Council. And the second set of remarks will be more focused on the practice of the human rights organs and how the human rights organs can play a role in the peace building and sometimes with a lot of challenges in some post-conflict situation. So my first set of remarks will be indeed focused on the practice of 2017 and 2018 of the UN Security Council. And it's very interesting regarding this link between peace and law and peace through law, etc. It's very interesting and fascinating to see how the wording of the resolution of the Security Council is changing. And what I mean is that the resolutions adopted during the 90s were in general broad resolutions with referral to the respect of international law by states or international law by the respect of international law by the UN. But now in different areas of the action of the Security Council, the referral to the body of international law, international human rights law, refugee law, international humanitarian law, or even international criminal law is more and more precise. I do not have time to develop, but I just give you 4 examples where we can find, as human rights lawyers, very interesting things and very interesting referrals made by the Security Council. The first one is about the protection of children during armed conflict. It's exactly what you said. Now, the resolution of the UN Security Council do not mention only the international obligation of state, and for instance, the prohibition not to use children during armed conflict. But the Security Council resolution does highlight the obligation of private actors not to use children during armed conflict, and with precise legal reference to the International Convention on the Right of Children, for instance, or the protocol to this convention. And it's very interesting because the protocol to this convention does mention the role of private actors in the using of children during armed conflict and forced involvement of children during armed conflict. So it's one example where we see the Security Council using more and more precisely this legal body and this international legal body, and the reference are more and more precise. The second example, I will not develop, but you can find this in a very recent resolution of the Security Council, is about an old practice, but it's now more and more known. It's about the forced starvation of civilians used as a weapon of war. And it's very interesting because when you read the resolution adopted by the Security Council in May 2018, it's like it's a very legal document with reference to the corpus of international humanitarian law, international criminal law, and the Security Council highlights the fact that the forced starvation is an element, or maybe an element, of war crimes, and even if it's committed by private actors or public actors. So it's, again, another very interesting example. The third example, it's about the protection of cultural property during armed conflict. So in previous resolutions, the obligation to respect cultural property was made, but from a very broad manner. And in a resolution adopted in 2017, the UN Security Council did point out the fact that in the current conflicts, we can see that the cultural property is destroyed by private actors. And the Security Council does recall this international legal framework protecting cultural property, and calls the states, the regional organizations, the international organizations to make private actors to respect this international legal body. So, as we have seen, the Security Council is more or less aware of the new aspect of conflict, and the war is not only, as you said, President, war is not only state against state, but the Security Council does recognize now that we have more and more complex conflicts. And the fourth illustration, but I will not develop, it's more well known, it's the fight against terrorism. And it's very interesting to see how the resolutions of the Security Council have changed. The resolution adopted in 2001, 2002 made no reference to the need to protect fundamental rights or international human rights law, etc. But now, in the more recent resolutions adopted in this field, fight against terrorism, the need to respect the rule of law is more and more highlighted by the Security Council. But you know that it's linked, or it's based on the pressure from the European Court of Justice, so the EU Court of Justice and the European Court of Human Rights. And these two bodies delivered judgments saying to the Security Council, okay, you can fight against terrorism, but you have to respect some basic rights as the right to a court or the right to a lawyer, etc., etc. So I'm not saying, of course, that the practice of the Security Council is perfect, and as you say, there are a lot of challenges in this UN collective security system, but we are discussing peace and law, and it's very interesting to see this growing idea that the mandate of the Security Council cannot be achieved without respecting international law. And I think it's not just a formal referral to international law. I think there's a real change of mind in this referral to the international legality. Of course, there are a lot of problems and there are a lot of challenges, but I think it's an encouraging point in the practice of the UN Security Council. But the second aspect I would like to develop a little bit more, it's about the role and the links between the practice of the human rights, international human rights organs and peace and conflict situation or post-conflict situation, etc. And when I talk about international human rights organ, I talk about the UN treaty bodies, and as Professor Touvna mentioned, for instance, the UN Human Rights Committee, but also the regional courts, the European Courts of Human Rights, the Inter-American Courts of Human Rights, and the African Court of Human Rights. And first, I would, just because we are, this year we are celebrating the anniversary of the Universal Declaration of Human Rights also, so I would like just to remind that the very first words of the Universal Declaration put together dignity, and I'm quoting, dignity, equality, justice, and peace in the world. So, of course, these values on which the Universal Declaration is based and is adopted are still challenged by the practice, as we have said, and by the pushback of the states, but it is at the basis of this philosophy of the Universal Declaration. And I also mentioned that in this Universal Declaration, and of course it's linked to the activity of the Academy, in this Universal Declaration, there's a provision about education. It's Article 26, paragraph 2. And it's very interesting to see that the aim of the education is to bring peace. And it's you know, in this peaceful objective that we have to protect education, to develop education, and to promote education. And in other human rights treaty, I could not say that there is a human right to peace. It does not really exist. It may be a political motto, but it's not, you know, on a legal basis, it does not exist. But in some human rights treaties, as the African Charter on Human and People's Rights, peace may also be seen as a collective right. So in the African Charter, adopted in '81, there's a provision, and peace is protected as a collective right. But the main, I would say, if I have to sum up the practice of the human rights organs, I would say that the main message from this practice, and when I talk about practice, it's case law, general comments, advisory opinions, etc., adopted by different human rights organs. The main message is not so different from the message brought by the International Court of Justice: no peace without justice. And this concept of justice has different dimensions, and all these dimensions today are challenged, not only by the states or by the pushback of the states, but because sometimes we do not know how to deal with these different dimensions of justice. Criminal justice, of course, civil justice, I will say a word about this, but also social justice. And I totally agree with what you say about prevention. And social justice, we do not think enough about this, but the link between social justice and peace, and how situation of poverty, extreme poverty, may lead to conflict. And maybe it's a very significant challenge international organizations, states, and NGOs are facing today. So first, a very swift word about criminal justice. No peace without criminal justice. Of course, and in general, we all know this, it means that the fight against impunity is a very significant feature of the case law of human rights organs, the case law of the Human Rights Committee, but also the case law of the Inter-American Court or the European Court of Human Rights. And whatever the context or the circumstances could be. So internal conflict, armed conflict, international armed conflict, fight against terrorism, other disaster, etc., etc. And in this context, there are a lot of judgments adopted by the Inter-American Court of Human Rights or the European Court of Human Rights, for instance, regarding law of amnesties. And it's very interesting because on this we have the tension between peace and justice. Because in general, before human rights organs, states do justify law of amnesties in the name of the peace and in the name of national or social reconciliation. But of course, the human rights organs considers, of course, there's some, I would say, some decision may be different, but in general, human rights organs do consider that law of amnesties are contrary to the right to a tribunal and the right to a court. And more generally, in the case law of the European Court of Human Rights or Inter-American Court of Human Rights, these kind of laws are contrary to the right to truth. And it's very interesting because this right to know about the past and to know about the conflict, the roots of the conflict, etc., is now recognized as a right and as a human right, and the victims may plead based on this right to truth. And of course, the fight against impunity implies also the obligation, the state's obligation to prosecute, to punish, etc. And in this context, the case law also of the ICJ is very significant. So very recently, an interesting judgment was adopted and delivered by the Inter-American Court in 2018 regarding the state's obligation to prosecute and punish against Brazil, prosecute and punish authors of crimes against humanity and how and what is the extent of this obligation, etc. Swift word on the two other aspects of justice. Civil justice, because peace is not only about prosecuting or punishing authors of grave and massive violation of human rights, but it's also about repairing the consequences of violations of human rights. And I have the impression that it's one of the main challenges faced with by human rights organs, but not only. I know that the ICJ, there's a pending case regarding reparation in context of an armed conflict. And also, as you know, it's a challenge faced with by the ICC, how to repair, what it means, does money settle everything, or we have maybe to think about another form of reparation. But it's very difficult because, as President Bode said, we have built international law based on interstate conflict. So it's very difficult to think about reparation in other kind of contexts, but not only in context of state responsibility between states. Social justice is the third dimension of justice, and I think, of course, it's very linked to the need to achieve peace. But maybe it's one of the other very significant challenge, because, as you may know, and I totally agree also with what you said about this non-universal dimension of international law. As you know, in general, even if we say that human rights are universal, it's not in practice the case. And in the Western countries, when they talk about human rights in general, they have in mind civil and political rights. But the rest of the world is talking about economic, social, and cultural rights. But Western countries, most of the time, do not want to hear about these. And I think this dimension of social justice is a blind spot of the human rights practice today. Even the practice of the Human Rights Committee, so that will be one of my aspect of my mandate. But I think it's very dangerous because if we do not work on this social justice aspect, we do not work on the root of conflict and this preventive dimension of conflict. It's not only about territories, etc., but most of the time, some conflicts do have their root in social inequality, and it's very significant now. It's one of the most important challenges, but it's very significant to face with this. But I see that the time is going, so if you want, I can leave you there, and if we have time, we can go on discussion. Thank you.
Thank you very much. So, ladies and gentlemen, time is running fast. Since we are very lucky to have the Vice President of the International Court of Justice, which is not, every day, I will give her the floor because I'm sure that the challenges put by Dr. Butt would inspire some kind of explanations. But before that, perhaps I would like to know if some of you would like to take the floor. And if this is the case, I would like to know to say what and how long in order to be able to deal with the time. Who would like to say something or perhaps put a question? A question or say something? A question, that's good. A question, short one. Okay, so we'll take 4 questions and then we go back to the podium. And first of all, I will give the floor to Vice President Schur. Would you like to put your question?
Thank you very much. Hello, my name is Nicholas Ortiz. I'm a jurist and legal advisor in public international law. First of all, I want to extend my sincere gratitude for all the valuable insights that this distinguished panel has brought to the table. The international legal order, as pointed out by several of the panelists, faces many challenges from external forces. But I'm particularly curious about what your thoughts are on internal challenges. So I'm referring to the dynamics between different subsets of international law. If you've seen the news lately, you know that the African Union is bringing a motion to have an advisory opinion on the question of immunities in relations to the Rome Statute and, of course, Omar al-Bashir, the sitting head of state there. I want to know what your thoughts are on such challenges. Do you think that they strengthen the rule of law, or do you think that they open up gaps in the international legal order? Thank you.
Mm-hmm.
The sound is not good.
Got it.
Perhaps we take another question.
I would like to ask a question about a concept which is called the rules-based international order. There's a lot of talk lately about states having to behave in accordance with the rules-based international order. And just wanted to hear from the panelists, and notably from Judge Xu, if she sees a sort of equation that a rules-based international order is in fact the application of peace through law. Could she maybe comment on that?
Thank you. I would like to thank the members of the panel for their interesting interventions. And I would like to come back to what Professor Touvenin said in his introduction about the systematic destruction of the legal standards and multilateral treaties which we have built up over the past 100 years. And you referred also to the United Nations Secretary General's meaning on that. So my question would be, can the members of the panel, or maybe also other participants here, give us an idea on how we could react? Because you were referring especially to the civil society. Now here we are. What can we do?
I have a question for Judge Xu. You mentioned that a lot of the cases of the ICJ are about territorial disputes. Now, a lot of these territorial disputes involve great powers, such as the disputes over the Kuro Islands, or the South China Sea, or Kashmir. However, it's been traditionally very hard to get the great powers to agree to use the ICJ system. What is the ICJ currently doing to promote the use of the ICJ by the great powers, and also once a verdict has been rendered, how to enforce or at least promote that verdict?
Thank you. Judge Shui, would you like to?
Can I really like to engage in this conversation. I apologize, I did not have time to take part in the previous one, so I'm a little bit delinked with your active discussions. I first would like to thank Dr. Bott for his 3 wonderful questions, so I could not help asking for the floor again. First of all, I don't think that peace is an elusive concept, it's a relative concept. Why? Because conflicts, differences, and disputes exist at anywhere, at the international level, national level, regional level, even in your family. So it's a perpetual pursuit for settling these disputes. That's the peace we have in mind. In other words, this is a continuous process. It's not some end of a story. Secondly, your question asked about relevance or irrelevance of international law in today's world. We have to understand the international is not static, it's developing. For instance, give an example, just from Second World War. And right after Nuremberg Tribunal, Tokyo Military Tribunal, and you see international very much develop around international criminal law. And then you have the decolonization process. There you have the right to self-determination. And then you have the resources problem with the development. Then you have the permanent sovereignty over natural resources principle. And then Law of the Sea Conference with all the rules regarding to maritime entitlements of the coastal states. And then further on, we have economic and trade law. And then today, very much on human rights and economic development and environmental protection. So each time you see the development, the law never leaves. It always follows. So it's not the solution to everything, but it's only part of the solution. I recall when one of the American judges, look at experience of the First World Court, that's Permanent Court for International Justice. And when he evaluated the function or the role played by the PCIJ in maintaining peace and preventing war, he said, the Permanent Court is nothing but a footnote. Very pessimistic. But if you look at its influence till today of the World Court, you could see how much it laid foundation for today's World Court. So it's gradual development. We have to understand for the past, the war is the means for settling international disputes between states. Now we abandoned the war, the means of war. Then we have peaceful settlement means, but still it's not enough. And for a long time, it's mainly the states, disputes between states. Now you have non-state parties. And you have different problems arising from advancement of technology, like cyber crimes. So you have to constantly react to the reality. So that's the function we are talking about. And then, in this process of constantly seeking for resolution, of course, what kind of law we are going to apply? And you have to gradually develop. And that's the function, the mission of international lawyers. But first of all, is the decision-making makers and the civil society, and now the people. And we have multiple players at international level due to globalization and due to technological development. It's able for people to get on the same platform and talk to each other. So that's the three questions I have in mind. But now back to the four wonderful questions. How you overcome these so-called internal conflicts of different laws? We address fragmentation issue of international law for quite a long time. For instance, when you have the human rights issues vis-à-vis environmental protection, and you have state immunity vis-à-vis international criminal law. But I think organically they are linked. You think theoretically they are in conflict, but when you have a specific question, it'll be different because the whole structure is there. And that's why we need an international, in addition to Dr. Bott's question, international law now has become a common discourse for states, for people to talk to each other. You could come from different political background, cultural background, ideological background. But when you come to this international law and use this language, everybody understands. Then quickly you can identify common denominator. And of course, even so, we could have different interpretations. And that's why some scholars ask, is international law international? And that would be another theoretical issue. And I understand on the recent developments, whether we can see the recent phenomenon as a challenge to the rule of law. Of course, first of all, how you define the concept of rule of law. But this kind of a challenge, I think, is always there. But more deeply, we should look at what's really going on in the world. Why you have these differences, challenges. At the national level, it reviewed as policy debate, national policies. And on the world level, it seems the rise of nationalism vis-à-vis internationalism. But I think this is the phenomenon of profound changes we are going through. So it's not a challenge to the rule of law per se, but it gives us a lot of food for thought as how we should pursue in the future for global governance. And I'm not so sure I catch the third question, but I think the last question I must answer because directly addressed to the region I know better. I understand the South China Sea has attracted a lot of attention, and one of the things is whether the relevant countries would bring the matter to international courts, whether they accept the jurisdiction of the court. First, as far as this court is concerned, and as many other concerns, because this is a general principle, that is the principle of consent. In international law, we know there is a basic principle, that is a freedom of a choice of a means of settlement of international disputes. In other words, the states have the freedom to choose whatever peaceful means they think appropriate for the settlement of a particular dispute. And whether the coastal states in South China Sea, relevant states, would like to come to the court is up to their consent. The court cannot drag them here. But you raise a very good issue, that is, today, the big powers, it seems, are not interested in judicial settlement. After Nicaragua versus United States case, U.S. withdrew its compulsory jurisdiction declaration. from this court, no longer accept compulsory jurisdiction of the ICJ. After nuclear test case brought by Australia and New Zealand against France, France withdrew its compulsory declaration on compulsory jurisdiction of the court. And among the P5s of the Security Council, only UK still accept compulsory jurisdiction of the court. I can't guarantee for the future of its action. But what does mean? It means when matters of national fundamental interests are involved, states may not like the idea to submit the dispute to third party. But you can't say they are not pursuing to settle their dispute through peaceful means. If they stand to negotiate, stand to seek a solution, political means, other means, is perfect. International law recognizes that right. So whatever, at the end of the day, what is required of states in international is they must do their best to pursue the settlement of their dispute through peaceful means. That's what is required by Article 2, Paragraph 3 of the Charter. Sorry to take too much of your time.
Oh, thank you very much. Thank you very much. I think it's a very fair answer to the last question. I will answer the third one by concluding what can we do, and perhaps I would like to propose to Dr. Bott and to Eric de Baat, who's here, perhaps to have a reflection on how could we convey or invite, create here in the Peace Palace kind of a permanent Hague Peace Conference. It's like a shame that the last peace conference in the Peace Palace was in 1907. Why not another one tomorrow? And why not permanent? I think the Peace Palace is there for that, and we should use it for that. We would need the civil society, probably a state, a leading state. Why not Netherlands? I don't know. Thank you so much for having been so patient, and please enjoy the rest of the day and the rest of the conference.